Hi, can you imagine a country of continental size on the other side of the globe and that is willing for investments and is ready to safely protect your intellectual property rights? This is Brazil. And today we will talk a little bit about its numbers and how to protect inventions and utility models in our jurisdiction. The content of our talk today is Brazil in numbers, the next 10 years, patent highlights, national phase applications through PCT and Paris Convention, fast tracks, Brazilian PTO's backlog reduction plan, and our final remarks. Brazil in numbers. Our capital is Brasilia. It's located in the Midwest region of our country, which was officially inaugurated in 1960. Our official language is Portuguese. Our territory is the world's fifth largest country in territorial size. The number of countries bordering Brazil is 10. Our population is 210 million people. And we have 90 million people that are economically active. Our urban population is about 85%. About our ethnic groups, 46% of people are white, 45% are multiracial, almost 8% are black, and less than 1% are Asian and indigenous. Our life expectancy is about 75 years. Men, something like 72 years, and women, 79 years. Concerning our Human Development Index, in 2017, Brazil was ranked in 75th among the 188 countries. Concerning our religions, 64% of our population is Catholic, 22% evangelical, 2% Spiritism, less than 1% belongs to Afro-Brazilian religions, 8% doesn't have any religion, and 2.5% belongs to other kinds of religions. Our gross domestic product, GDP per capita, is almost $9,000. Our GDP growth rate compared to the previous year is 1.13%. Our unemployment rate is around 12%. Our inflation rate in 2020 is around 3.56%. Our export of goods in 2019 was around $222 billion. Our main partners are China, United States, Argentina, and the Netherlands. On the other side, the import of goods in 2019 was $184 billion, and our main import partners in 2017 was China, followed by the US, Argentina, and Germany. Now, talking about the next 10 years. In accordance with the Brazilian Ministry of Science, Technology, Innovation and Communication, MSTIC, it was recently published a 10-year strategic plan in order to enhance innovation and improve the life quality of the Brazilians. The 2020-2030 strategic plan follows the following targets and principles. Firstly, why we're doing it? We're doing it to generate knowledge and richness and also to contribute for a better life quality of the Brazilians. How we're doing it? We will enhance integrated performance of the MSTIC, improve internal and corporate governance and management, and we strengthen our national and international relationship. And what we're going to do? We will improve the domestic science capacity. We will promote universal access and better quality telecom services in Brazil, increase Brazilian autonomy regarding space products and services, promote nuclear technology development and its uses, promote entrepreneurship, innovation, and applied technologies, contributing to a sustainable development. The 2020-2030 strategic plan of the MSTIC is strictly connected to the protection and enforcement of intellectual property rights in Brazil. In this sense, Brazil has a robust set of treaties, laws, and regulations regarding intellectual property rights, such as the industrial property law, the copyright law, the software law, Paris Convention, Patent Cooperation Treaty, the TRIPS Agreement, and also several other Brazilian PTOs resolutions regarding IP matters. Now, concerning the patent highlights, we may say that in Brazil, an invention is patentable if it satisfies the requirements of novelty, inventive step, and industrial application. An object of practical use or part thereof is patentable as utility model if it's susceptible of industrial application, has a new form or arrangement, and involves an inventive act that results in functioning improvement in its use or manufacture. The following are not considered to be inventions or utility models. 1. Discoveries, scientific theories, and mathematical methods. 2. Purely abstract conceptions. Number 3. Commercial, accounting, financial, educational, advertising, reference and inspection schemes, plans, principles, and methods. Number 4. Literary, architectural, artistic, and scientific works or any aesthetic creation. Number 5. Computer programs per se. Number 6. Presentation of information. Number 7. Rules of games. Number 8. Surgical techniques and methods, as well as therapeutic or diagnostic methods for application to a human or animal body, and all or part of natural living beings and biological materials found in nature, even if it's isolated therefrom, including the genome or germplasm of any natural living being and the natural biological process. An invention and an utility model are considered to be new if they are not part of the state-of-the-art. The state-of-the-art consists of everything became accessible to the public prior to the filling date of the patent application, by means of a written or oral description, by use, or by any other means in Brazil or abroad. For the purposes of determining novelty, the entire content of an application filed in Brazil are not yet published, shall be considered to be state-of-the-art from the date of the filing or of claimant priority, provided that it comes to be published, even subsequently. The provisions of the preceding paragraphs apply to an international patent application filed according to a treaty or convention in force in Brazil, provided that there is national processing. The disclosure of an invention or utility model shall not be considered to be state-of-the-art if it's secured during the 12 months preceding the date of the filing or priority of the patent application if made. 1. By the inventor. Number 2. By the Brazilian PTO by means of an official publication of the patent application filed without the consent of the inventor, based on information obtained from him or as a consequence of actions taken by him. Or number 3, by third parties, based on information obtained directly or indirectly from the inventor as a consequence of actions taken by him. An invention is endowed with inventive step, provided that to a technician versed in the subject, it is not derived in an evident or obvious way from the state-of-the-art. On the other hand, an utility model is endowed with inventive act, provided that to a technician versed in the subject, it's not derived in a common or ordinary way from the state-of-the-art. An invention and utility model are considered susceptible of industrial application when they can be used or produced in any kind of industry. Now, concerning priority issues, a patent application filed in a country that maintains an agreement with Brazil or in an international organization and that produces the effect of a national filing shall be assured the right of priority within the time limits established in the agreement, and the filing shall not be invalidated or prejudicated by events occurring within such time limits. The claim of priority shall be made at the time of the filing and may be supplemented within 60 days by the other priorities prior to the filing date in Brazil. The claim of priority shall be proven by a proper document from the country of origin, comprising the original application number, date, title, specifications, and, if applicable, claims and drawings accompanied by a full translation of the filing certificate or equivalent document containing identifying information on the application for which content the applicant is solely responsible. If not submitted at the time of the filing, the proofs must be submitted within up 180 days of the date of the filing. For international applications filed under a treaty in force in Brazil, the translation referred to in paragraph 2 must be submitted within a period of 60 days of the date of entry into national processing. If an application filed in Brazil is faithfully reproduced in the document from the country of origin, a statement by the applicant about that shall be sufficient to replace the free translation. When priority is obtained by assignment, the corresponding document must be submitted within 180 days of the filing date, or, if applicable, within 60 days of the date of entry into national processing, and consular legalization in the country of origin shall not be required. The failure to provide proof within the limits provided for in the previous information shall result in the loss of priority. In the case of an application filed along with a claim of priority, the request for early publication must be followed by a proof of priority. Now, about non-patentable inventions and utility models, we may say that the following are not patentable. Number 1, anything contrary to the morals, standards, or of respectability and public security, order, or health. Number 2, substances, materials, mixtures, elements of products of any kind, as well as the modification of their physical-chemical properties and the respective process for obtainment or modification when resulting from transformation of the atomic nucleus. And number 3, all are part of living beings except transgenic microorganisms that satisfy the 3 requirements of patentability: novelty, inventive step, industrial application, and which are not mere discoveries. For the purposes of the Brazilian industrial property law, transgenic microorganisms are organisms accepted for all or part of plants or animals that express by means of direct human intervention or their genetic composition a characteristic normally not attainable by the species under natural conditions. A patent application, in accordance with the conditions established by the Brazilian PTO, shall contain request, specifications, claims, drawings, if applicable, abstract, and proof of payment of the filing fee. Once the application has been submitted, it shall undergo a formal preliminary examination and, if found to be properly documented, shall be docketed. The date of submission shall be considered as the date of the filing. Processing and examination of the application. A patent application shall be kept secret for 18 months from the date of the filing or of the oldest priority, if any, after which it shall be published. The publication of the application may be anticipated at the request of the applicant. The publication shall contain data identifying the patent application and a copy of the specifications, claims, abstract, and drawings shall remain available to the public at the Brazilian PTO. The biological materials shall become available as well to the public upon the notification. After publication of the application and up to the end of the examination, interested parties may submit documents and data to assist the examination. The examination shall not begin before 60 days from the publication of the application. In order to better clarify or define a patent application, the applicant may take changes until the time of the request for examination, provided these are limited to the subject matter initially disclosed in the application. The examination of a patent application must be requested by the applicant or by some other interested party within a period of 36 months of the date of the filing, under penalty of having the application dismissed. After the examination has been requested, the following must be submitted within a period of 60 days whenever requested, under penalty of having the application dismissed. Number 1. Objections. Search for prior art and results of examination for granting of a corresponding application in other countries when priority is claimed. Number 2. Documents necessary to regularize the processing and examination of the application. And number 3. Free translation of the proper priority document if it was not replaced by a specific statement about its content and validity. At the time of the technical examination, a report, search, and an opinion shall be prepared with respect to: number 1. Patentability of the application. Number 2. Suitability of the application given the nature claimed. And number 3. Reformulation or division of the application. Or number 4. Technical requirements. When the opinion determines the non-patentability of the application or the incompatibility of the application to the nature claimed, or makes some demand, the applicant shall be notified to submit comments within a period of 90 days. Once the examination is concluded, a decision shall be handed down, either approving or rejecting the patent application. Granting of the patent. A patent shall be granted after the application is approved and proof of payment of the corresponding fees has been furnished by means of issuing the respective patent certificate. The payment of the fee and the respective proof of payment must be done within a period of 60 days of the approval. The aforementioned fee may also be paid and proven within 30 days of the time limit referred to in above, independently of any notification upon payment of a specific fee, under penalty of having the application definitely dismissed. Number 3. A patent shall be deemed to have been granted on the date of the publication of the respective act. The patent certificate shall contain its number, title, nature, name of the inventor, the identification and domicile of the title holder, the term, specifications, claims, drawings, as well as data regarding priority. Regarding the term of the patent, an invention patent shall remain in force for a period of 20 years and a utility model patent for a period of 15 years from the date of the filing. The term shall not be less than 10 years for invention patent and 7 years for utility model patent, beginning on the date of the granting, unless the Brazilian PTO has been prevented from examining the merits of the application by a proven pending judicial dispute or for reasons of force majeure. Protection granted by the patent. The scope of the protection granted by the patent shall be determined by the content of the claims and interpreted on the basis of the specifications and drawings. A patent grants on its title holder the right to prevent a third party from, without his consent, producing, using, offering for sale, selling, or importing for these purposes. Number 1. A product that is the object of the patent. Number 2. A process or product directly obtained by a patented process. The patent holder is assured the right to obtain indemnification for improper exploitation of the object of his patent, including that which occurs between the date of the publication of the application and the date of the granting of the patent. Now, about national phase applications through PCT and Paris Convention. Considering the fact that Brazil is also part of the Patent Cooperation Treaty and also the Paris Convention, it's possible to protect international patent applications in Brazil if they are filed in accordance with the Brazilian PTO's rules and within specific deadlines, which are 30 months for PCTs and 12 months for conventional applications. It's important to bear in mind that those deadlines are counted from the filing date of the first priority used to ground the national phase application. Now, regarding the PCT rules, the required documents are the following: payment receipt of the Brazilian PTO's official fees, complete descriptive report, claims, abstract, drawings and or flowcharts if applicable, power of attorney. Please note that no notarization or legalization is required. Identification document with the essential data of the international application, such as international publication, written opinion of the International Searching Authority, international search report, among others. Annuities. The annuities are due from the beginning of the third year, from the date of the filing of the international application filed under the PCT. The payment of the expired annuities shall be made within 3 months from the date of the filing of the national phase application. The non-payment of the corresponding annuity will result in the shelving of the patent application. Examination request. The examination request must be required within 36 months from the date of the international application, under penalty of shelving the application. The application has the same deadline mentioned above to proceed with the claim amendments of the corresponding patent application. Late filing of documents. The applicant has 60-day term for the filing of the national phase to proceed with the late filing of documents, such as power of attorney, complete descriptive report, and priority documents. Application based on Paris Convention. The required documents are essentially the same of the PCTs, which are the payment receipt of the Brazilian PTO official fees, complete descriptive report, claims, abstract, drawings and or flowcharts if applicable, the power of attorney, and priority document. Regarding the annuities of the Paris Convention application, the patent application's annuities are due 24 months from the date of the filing of the national phase. The non-payment of the corresponding annuity will result in the shelving of the patent application. Examination request. The examination request must be requested within 36 months from the date of the filing of the national phase, under penalty of shelving the application. The applicant has the same deadline above to proceed with the claim amendments of the corresponding patent application. Late filing of documents. The applicant has 60-day term from the filing of the national phase to proceed with the late filing of documents, such as power of attorney, complete descriptive report, and priority documents as well. Now, regarding fast tracks, it's a fact that a patent application in Brazil may take several years to be granted. However, nowadays the Brazilian PTO allows the fast track of determined patent applications. According to a survey carried out by the Brazilian PTO, it's estimated that the average time for granting a patent application is between 5 to 8 years. According to the Brazilian PTO's patent director, Mrs. Liane Lage, innovation in Brazil is far below what it would be, and that is delay in the analysis of the patent applications is due to the lack of structure, investment, and human resources, which characterizes an imbalance between the number of orders made in Brazil and the ability of examiners to perform such service. In 2019, the Brazilian PTO initiated a project to improve the priority procedures for determined patent applications, thus seeking to depressurize this procedure. For the priority procedures, the time for examining and granting a patent application may be reduced to just 2 years, and in some cases, even less. In view of the above scenario, and aiming to a better performance in relation to other countries around the world, the Brazilian PTO, through resolution number 229/2019, made available several ways to speed up the examination of any patent application. Now, regarding the applicant categories for priority examination application, we have the following: applications belonging to an individual aged 60 years or over, applications belonging to individuals with physical or mental disabilities, applications belonging to an individual with a serious illness, applications belonging to a scientific, technological, and innovation institution, ICTs, and applications belonging to small and medium-sized entities. Regarding the specific situations for requesting a priority exam, we have the following: applications whose granting is a condition for obtaining financial resources, applications whose object is reproduced by a third party without authorization. And we also have specific subjects for requesting priority exam, which are the following: applications that demand the protection of green technology, applications whose object is product for the treatment of specific diseases, and applications whose object is a product for treatment of COVID-19. It's very important to highlight that the fast track related to COVID-19 was implemented by Ordinance number 149/2020, and according to the Brazilian PTO itself, considering the pandemic declared by the World Health Organization, its impacts on public health, and the need for short, medium, and long-term measures and long-term to protect the population from the virus, the Brazilian PTO created a priority procedure for patent applications related to pharmaceutical products and processes and equipments and or materials for use in health for the diagnosis and prophylaxis and treatment of COVID-19. Patent applications examined by foreign PTOs. It's extremely important to emphasize that with the Patent Prosecution Highway, PPH, after a partner patent office ends up considering the patent application subject matter patentable, it becomes possible to prioritize the patent application of the same invention and holder with the Brazilian PTO. It should be noted that the request for priority processing may be requested at any time in the process. This period extends from the filing, communication, and remittance of documents to initiate the procedure with the Brazilian PTO, and extends until after the patent has been granted. In order to apply for priority processing, it's necessary to have a patent application filed normally and in regular course at the Brazilian PTO. In other words, firstly, it's necessary to file a patent application with the Brazilian PTO to later apply for priority processing. To be eligible for the new PPH pilot project, the first examination office must have a cooperation treaty signed and enforced with the Brazilian PTO. Currently, the Brazilian PTO partner offices are the US PTO, the JPO, the PROSU, also the EPO, CIPO, and UK IPO. Finally, it should be noted that each type of priority examination has requirements and deadlines to be fulfilled, in addition to specific documents that must be submitted to the Brazilian PTO in order to prove that the process is in one of the situations listed above. Brazil also has a backlog reduction plan provided by the Brazilian PTO. The Brazilian PTO initiated a specific project to fight backlog, aiming at substantive reduction of number of patent applications with examination required and pending decision in a period of 2 years. The backlog reduction plan strikes almost 150,000 pending patent applications that on August 1st, 2019 met the conditions established by the Brazilian PTO. Now, as final remarks, we may say that Brazil is a huge country with international and national regulations regarding the protection of intellectual property rights. As any other emerging country, we still have several homework ahead. On the other hand, we are constantly trying to overcome our difficulties and trying to finally aboard the innovation track of other developed economies. And considering our great efforts, especially in the last 20 years, we are sure Brazil will offer a very fertile ground for our international business partners.